Hi, my name is Michael Sandler, and once again, I'm here to talk to you about topics in bankruptcy. When you file bankruptcy, a lot of people say after the case is filed, well, when are we going to court? The answer is you typically don't go to court in a bankruptcy case, believe it or not. In the old days, before you get your discharge, you had to go before a judge and be lectured, but with the increase in the number of cases that have been filed over the years, that isn't really practical anymore. Judges are way too busy to lecture each and every person that files bankruptcy. When you file bankruptcy, Chapter 7, about 5 weeks after you file, there's a meeting with a court official called a trustee. Now, the trustee's job in a Chapter 7 is to see if you have any assets that he can liquidate and then distribute that money amongst your creditors. He's not looking, or he or she is not looking for your household goods, your television, your clothing, things like that. They're looking for more big-ticket items like newer cars that are paid off with a lot of equity, houses with a lot of equity, stocks, bonds, businesses, things like that. This time of year, and I'm taping this in early April, tax refunds are a big topic that trustees are interested in. But about 5 weeks after you file, there's a meeting with that trustee. Here in Alexandria, they do about a dozen every hour. It's in a conference room. They call you up to the table one at a time. I'm there with you to hold your hand if need be. And it typically takes about a minute or two. That's it. In a Chapter 13, there's also a meeting with a trustee, and again, it's about 5 weeks after you file. But the trustee isn't looking to take any of your property or liquidate it. And in Chapter 13, you're keeping off your property that you want to keep. The trustee in a Chapter 13 is sort of the gatekeeper between you and the court. The trustee is looking over the plan that you filed, seeing if the income and expenses are reasonable and realistic, and if the plan is addressing and paying the types of debts that need to be paid. If the trustee has no problem with the plan or the schedules that are filed, he will recommend approval to the court, and the judge will sign off on it. If he does have a problem with anything that has been filed, he'll file an objection, at which point you can either amend the plan to meet the objection, come to some kind of compromise with the trustee, or if you think the trustee is just totally off base, go to court, have the judge decide. If the judge decides in your favor, plan is approved, start making your payments. If the judge agrees with the trustee, the plan is rejected, and you have 21 days to file a new plan. Your case isn't just thrown out. In that sort of objection, you would often have to appear and give testimony regarding perhaps income and expenses. But oftentimes, if something is filed with the court, your attorney represents you, and you don't need to appear. Appearances by debtors in bankruptcy court tends to be on the rare side. But if you need to be in court for any reason, that's when your attorney should properly prepare you for that court appearance. But again, typically in a Chapter 7 or Chapter 13 case, no court is usually necessary. This is Michael Sandler, answering your questions on bankruptcy.